Good morning, good afternoon, good evening. Whichever it is, my best wishes are always with you. Thank you again for being there. And this is a new topic that you've taken up today. Privacy has become a major concern across the globe, and there have been a lot of considerations of benchmark being GDPR and GDPR versus FA or CCPA, PDPA, PDPB, PIPEDA. So many standards. So now GDPR being there more from the UK, European Union perspective, and there is CCPA, CPRA, and stuff from the US perspective. We got quite a few requests for comparing these two standards, because for our company, we have been doing this for many companies where they are looking at both, because most of them are multinationals, and they say they want to do both because they've got clients in the UK, Europe, and also in the US. So how would you manage? Should we do two standards, or can we integrate them, or how do they compare against each other? Which is more stringent? Is it possible that we do GDPR and then end up doing CPRA by default? How does it work? So that's what's the topic for the day today. So the topic, as you must have seen, the future of data privacy, examining the impact of GDPR and CCPA on business practices. How would it impact for your organization as you grow into on a multi-scale basis? All right, I hope you can see my screen, and I really hope you can hear me very well. So in case there has been any issues, my team is standing by, and we are there with you to help you make the most of this subject, make the most of this topic, and of course do drop in your queries as we go by. And in case you're having any trouble in hearing me, or in understanding what I'm saying, or even seeing my screen, or suddenly the screen is frozen, do let me know. You've been doing this for more than 5 years. We know how it moves. All right, so someone had a problem hearing me, and now the person can hear me. Thank you again for the confirmation that you can hear me well now. Thank you again for being there, all of you. So these are the topics that we had promised that we would cover: overview of both GDPR and CPRA, key differences between GDPR, CPRA, and of course the similarities, and the strategies for ensuring compliance with both standards. You really need to pay attention as we grow from the basics to the differences to the similarities, and how we can integrate them both, and what can, in my opinion, based on our industry experience, say could be the future of data privacy. All right, so there's a lot to cover. This thing is very important for you, for most of the people. That is a CPE points, continued professional education, which is asked by many standards or certifications such as CISSP, CISA, PCI standards, and all those things. So you can claim one point for attending the webinar, but please mind that we don't give any certificates. We've got hundreds of people attending. It's really not possible to customize certificates for each of them, especially since we are doing this for free. But you can put it up on the portal for whether it is ISACA or ISC or whatever be the case. And in case there is an audit query, we do answer them. But for that, you have to ensure that you are there till the end. All right. Okay, this is our YouTube channel. It has got more than 3,000 subscribers. It's like we are probably the most well-known on the internet for our content in our field, that is. All right, so feel free to subscribe. Everything is free. You can even see your past webinars. There are playlists for all the various subjects, whether it is PCI, GDPR, ethical hacking, HIPAA, SOC 1, SOC 2, laden with a lot of information. We got a lot of panelists. We had many panel discussion experts on our program, so you can learn from them, and everything's for free. And okay, as we go along, as I said earlier, do drop in your queries. We get many queries as we go along, quite a few webinars, and it's not really possible for me to cover all of them. So I try to answer a few, but what I promise you is that whatever the queries are, I will write back to you. So do drop in your queries, don't hesitate. And of course, in case you want us to take up a new subject in the next webinar, do drop a line on that too. All right, this is me. Most of you know me. In the list of attendees, okay, I can see quite a few of my esteemed clients also. Thank you again for being there. It's an honor. All right, so I've been there for like 30 years now, and I'm myself a PCI, QSA, CISA, CSSP. I've got my own company with InfoSec, and we've been there for not much to talk on me. All right, and towards the end, do leave your feedback at the end of the webinar. That is, you'll get a survey at the end. It will not take you more than 30 seconds to fill it. For all the time and the expense that we go through for this webinar, do try and leave your feedback, whether it is positive, negative, anything. It really helps. Do fill up that survey form for us, please. The introduction to the standard, where we start off with a brief intro on GDPR. Now, please remember that this webinar is not on GDPR or the California Privacy Rights Act. CCPA, CPR, they are both like tied up together. If you go to our YouTube channel, which you can see the link in the chat, as you can see, or if you're watching this on YouTube, you can see that in the description. And what can happen is that if you go to our YouTube channel, there are playlists. One of them is on the privacy, where you cover all GDPR, HIPAA. There is one webinar, that's one playlist just for GDPR. So all those things are covered over there. All the accumulation of all the webinars that you've done till date. So the CPRA, so we will be looking at both, but we're not getting into the details of CPRA, GDPR. So if you want to see that, you head out to our YouTube channel. While you are there, subscribe, click on the subscribe channel and click on the bell icon. So you get notifications when we upload new content, which is like one video a week or something. All right, a brief overview of GDPR. So it came out as a way of sanitizing data privacy laws across Europe, and then Brexit happened. So then UK came up with its own version of GDPR, but the European version and the UK version, there's not like a huge amount of difference. All right, so you can still call it GDPR, and if you're doing one, you'll probably end up doing the other also. All right, so GDPR is more for safeguarding data privacy of European Union citizens, UK citizens, and residents, and it transformed the organizational way of approach to data privacy. And of course, the types of data protected: health, genetic, personal ID, PII, that is name, email address, contact numbers, your address, all those things, your family history, your medical history, genetic history, biometric data, racial, ethnic, political affiliations, all those things is counted as sensitive information or private information or protected information under GDPR, right? So history: 1984, UK DPA came up, and then in 1995 the EU Data Protection Directive came up. Then in 2012 they announced plan for GDPR. 2016 it was approved by the EU Parliament, and then 2018 it gave a 2-year hiatus for you to get ready, and 2018, I believe June somewhere, if I'm not mistaken, or March. Anyway, GDPR kicked into place. So the fines pretty steep, and they have implemented this for many companies, including like Google and Facebook, and all have paid the penalties. Have been fined, rather. I don't know whether they paid or not, but they have been fined. Now fines up to 20 million euros, 20 million or 4% of global revenues. So anyone and everyone gets covered in this, whether you're a small company or a large giant. The impact will be felt across. So the key provisions, of course: lawful processing, being fair, transparent processing, data privacy, data subject rights, consent, where there is a huge focus on consent, privacy by design, and DPIA, data protection officer, awareness, training. So many things are clubbed into it. More than 90 articles are there rather. Very interesting read. It's all free. And again, if you need to know more, head out to our YouTube channel, go to the playlist on GDPR, and you can see the data. Now, according to PwC, PricewaterhouseCoopers, one of the big four consulting audit companies in the world, 77% businesses plan to spend 1 million or more on GDPR. Now, according to PwC, PricewaterhouseCoopers, one of the big four consulting audit companies in the world, 77% businesses plan to spend 1 million or more on GDPR. 77% of all businesses plan to spend more than $1 million on just GDPR. And of course, according to Cisco, 59% of security professionals who said that their organizations currently are meeting all of GDPR requirements. Like, we've got our offices in India, Singapore, Europe, we are there in the Middle East, and we are there in UK also. And we've got clients in India, in Singapore, who are compliant to GDPR, even though they are not there in UK, because that's how wide the impact has been, and the acceptability levels have been that high. So do not take this for granted. Do not assume anything over here. It's really very interesting, and you should go through it. And these are put down the 8 under GDPR. It is very comprehensive, and I cannot really cover this in detail. So the first is the right to be informed as to what your data is being used for, and why it's being collected, by whom it's being collected, and all those things. And there's a right to rectification. You have the right to reach out and even change your data based on your current position or whatever. and the right of access for you to be able to access that. That's why if you see in Facebook or even WhatsApp and all these different online channels, you can say download your data. Even in WhatsApp, you should try doing that, and you'll be shocked at how much data is collected by WhatsApp or is there on WhatsApp. So again, there's nothing. There are many people who are very scared of WhatsApp. I don't know why, but anyway, there have been some privacy concerns on that, and of course, there are many other channels, Telegram and Signal and all. But besides the point, you can go to all these sites, whether it is Facebook or WhatsApp or Gmail and stuff, and you can download. There are options under settings for you to download the set of entire data that particular site or that particular application has saved. So that's the right of access. And there's the right to be forgotten, erased. So you can simply say, erase my entire profile, and they have to do it. There are checks and balances, and I don't have time to get into it. So you cannot, but just to give you a flavor, you can't go to your telecom company, I demand that all my call records be erased. No, they won't do it because it's required to be retained by the law. So there are checks and balances for that. Or you can't go to the bank and say, all the transactions is my personal data. I demand that you close my account and erase all details of all transactions. It's not really absolute, it's not across. There are checks and balances for all these things, right? And there's a right to restrict the processing of your data. So you can say that a bank says that I'm going to give your data to my mutual fund arm where they will process the data and give you some mutual fund advice. You can reject it, right? So those things, it places the power in the hands of the end users who are earlier without any rights whatsoever on what is happening to the data, where the data is going, and how the data is being used or misused. And of course, the right to portability, data portability. So you can simply download your data from X portal and put it on Y portal in a very agreeable manner, in a very understandable manner. And there's a right to object. Of course, you can say, I'm not happy with this, or I don't like this, or change this, or do that, and they have to do it. And of course, the rights regarding automated profiling and decision making. I know it makes you gasp, yes, because this is being done all the time by the search engines like Google, where they are profiling, where they are making judgment calls on what you are visiting, why you're visiting, and they're giving you targeted ads. But there is again the checks and balances, because they're doing this because you've agreed to it in some way, filled up on form or accepted some terms of conditions, terms of consent, and you've given an explicit consent. So that's what I say. Just head out and to these portals and see what all data is over there. Anyway, moving ahead, the 10 key provisions of GDPR: privacy by design. Processing that law is that whatever is being processed is lawful, fair, and transparent. That's Article 5. We've given the references of the articles, all right? There's Article 5, Article 25, and then again under Article 5, limitation of purpose, data, and storage. And then Article 35 speaks about data protection impact assessment. What would be the impact in case of a breach? Something like a risk assessment for privacy. So if you're going for GDPR, then you need to do a GDPR. Again, if you need to know more, head out to our YouTube channel. You have the link in the chat box or in the comments description. Go to our videos on GDPR and you can learn all these things more in detail. And of course, the data subject rights, a list of rights, very, very exhaustive. And I've already covered that in my previous slide. And of course, data transfer as to where your data can be transferred for what purpose. Then there's a provision for a DPO, data protection officer. It's not necessary for you to keep this on your rolls, and it's not necessary for all the companies to have GDPR who are having GDPR to have a DPO. So there are some provisions for that as to who should be having a DPO and who should not. And it's not even necessary for organizations who are required to have a DPO to have a DPO on their rolls. They can also outsource this function. So for example, like you have seen the concept of a virtual CISO, right? So the same way there is the concept of the virtual DPO. So for example, our company does that. So somebody can say that I need a virtual DPO for 1 day a week. All right, moving ahead, consent. That's a very big blow to all those people who are misusing data, collecting data in a fraudulent manner. So consent is one of the key provisions of GDPR. Very, very interesting. You should read it. What should happen if there is a personal data breach? And last but not the least is awareness and training. These are the 10 key provisions of GDPR. We have given the article numbers. You can read it in case you are interested. Coming to CPRA. Now this is interesting. So it expands on CCPA, and this is CPRA. It came into existence in 2020, 2 years after GDPR. It was certified on December 11th, 2020, effective date December 16. And there's a 1-year look back provision from 1st Jan 2022. Now, who does it apply to? In case you're wondering, there is, again, you can head out to a YouTube channel. There's a webinar just on this. There is a CCPA, that is 1.0, CPRA, which has come out now. CCPA is California Consumer Privacy Act. So it was just like a regulation. Now this is a regulation now for profit organizations operating in California. So this was basically, restricted for the data of California businesses and California citizens. If I can go on a slight thing, slightly irritating. The reason being, now all the states can balloon into getting their own privacy act. So there's a New York Privacy Act, there's a Virginia State Privacy Act. So they're coming up with their own. I really hope they get their act together and come up with one law like what you see in GDPR and in the UK, Europe. So 25 million in gross revenues, that's profit. It is applicable to them. Buy, sell, or share personal information from more than 100,000 Californian citizens and generate 50% or more revenue from sharing or selling personal information. So the scope of CPRA is much more lesser than that of GDPR. And there is a key provisions, that is sensitive data and expanded breach liability, new enforcement agencies, audits and risk assessments required. And then there is a penalties for non-compliance. Here it is again not really as high as GDPR, but again it is there. Fines up to 7,500 for willful disregard of regulations per instance, that is. And additional fines for violation of sensitive information of minors, $2,000 for mistakes, 2,500 for mistakes due to negligence per incident. So there is 100 cards, so you multiply that, right? So it's not just you make a mistake, you just get away by paying. You lose 1,000,000 records and then you get away by paying $2,000. No, it doesn't work that way. You multiply that with this. These are the provisions, list of rights, and so you can see there's a lot of overlap with GDPR and CPRA. There's the right to delete personal information, right to correct inaccurate information. So again, the right to rectification, what you saw as a rights under GDPR, the right to delete, like the erasure right under GDPR, the right to restrict use of sensitive personal information assaulted under GDPR as you can object or you can control how the processing is being done, and the right to know about personal information collected, used, shared, or sold. So again, you have the right to know what all data is being collected. It's there under GDPR too. Right to opt out of sale of or sharing of personal information. Same thing are covered under GDPR as a right to choose what processing is being done with your data, and the right to limit use and disclosure of sensitive PI. You can see that under GDPR also. So there are some good amount of. We saw 10 provisions under GDPR, 6 key provisions under CPRA. There is a right for sensitive data. There's a new enforcement agency, that is California Privacy Protection Agency, CPPA, an expanded breach liability which came under CPRA, then audits and risk assessments, that's mandatory again CPRA, and additional privacy controls for Californians, and then additional rights to control their information. So this is really a big step, a good step, and I really hope it spreads across the United States, it becomes more pervasive, the scope increases across the board. And then now coming to GDPR versus CPRA, how does it scale up? The key differences, again, you can see the inception. CPRA came into full force on the 1st of January 2023. GDPR had almost like a 4.5 year, more than 4.5 years head start on CPRA. Considered as protected data, a big list. You can see under GDPR, identification number, email address, physical traits, genetic traits, economic background, cultural, so many things. But CPRA, slightly more leaner. Now, enforcement, it is enforced by the EDPB and the European Commission. And again, let me tell you that in GDPR, each state has its own ICO, Information Commissioner's Office. And CPRA is governed by the California Attorney General's Office. Geographical scope and liability across the board. All companies processing personal data of European and UK citizens is covered. Here it applies only that do business in California or process data or personal data of Californian citizens. And penalties, 20 million pounds or 4% of global annual turnover, whichever is higher. Under GDPR, massive penalties. And again, under CPRA, it is $7,500 per violation. So as I said, 100 records, you multiply that by 100. And then the territorial scope, similarities. Under GDPR, it applies to firm that operates in EU and even outside of EU and offer goods and services. Now, under CPRA, there is a bit of uncertainty if it applies to non-Californian companies or not. It depends on the definition of doing business in. So what do you mean by doing businesses? Do I need to have an office, or do you need to have a partner, or do I need to have clients in California? What do you mean by doing business in? So there are some uncertainties, which I'm sure that they will sort it out. It's a fairly new, like it's on the date of doing this webinar, it's like 3.5 months old. And GDPR has been like almost 5 years, right? Now, pseudonymization, anonymization, pseudonymization. It's the process of making personal data untraceable to an individual without extra information, right? So it's like an X-ray with some code embedded on it, patient key. But without having that key book, which maps the key with the patient, that X-ray, you'll never be able to find out whom it maps to. Is there in CPRA too? Controllers and processors, what is the difference between controller and processor? Controller is the one who decides what data is being collected or can be collected and why. Processor just follows orders from the controller. How and why the data is being processed. So the same way under CPRA, a business refers to a for-profit business entity that determines how and why consumers' data, personal data is processed, applies to businesses operating in California. What about children's or minors' personal data? Goes without a saying, children are seen as vulnerable. Special protection has to be provided for them. Depending on the legal boundaries, typically it's 16 years and it is 13 in some European Union countries. Children's data is considered as extra sensitive. Now, minors under 16 have opt-in rights under CPRA, and businesses must get consent to sell personal information of consumers under 16. For consumers under 13, a parent or personal guardian must authorize the sale of their personal data. Now, legal basis for processing data. Under GDPR, you can withdraw consent for processing, but again, whoever member or union or member state laws can derogate, means they can take away these rights. As I mentioned sometime earlier, is that based on the situation, the data can be used against the rights also, based on, of course, some legal provision. As I give you the example of the telecom or the bank or even government records, right? Under CPRA 2, if a business opts out, if a consumer opts out, the business cannot process the data against the wishes of the user. Now, the rights of individuals. That's the right of individuals. They have the right to data portability, object automated data processing, deletion and erasure, access personal data, rectify their personal data, and object. These are the various rights I just seen in the previous slides. Object to personal data processing, and then again under CPRA, they can request for the same rights get mapped out again, like with a different set of words. But there is a lot of overlaps between this. Now, strategies for ensuring compliance with GDPR and CCPA. So practical steps towards aligning. Let's go through a few quickly. Best practices. Again, you can see there's a beautiful reference point. There's a beautiful reference image that you can see. Understand the regulations. Appoint a DPO ASAP. Very important. Appoint a consultant auditor who can help you plan it very well. And then scope out and map of the data. That is what you are having and why you're having. Then invest in data inventory management. Conduct a DPIA before processing the data, not after. Then establish a consumer. This is going to be very painful. Establishing the consumer consent process. So many queries are there. Whether you can use the data already collected, can you do email marketing, and so many queries are there. If you have these queries, head out to your website www.vistainfosec.com. Go to the resources, go to the blog, and there are almost 300 articles that our team has put up. I have put up answering a lot of queries. Now, of course, not all 300 are for GDPR, but you can still go through it, answering all these queries. And then the process for implementing consumer rights, develop data processing and vendor management agreements. This is very, very important. The vendor management agreements is very, very important over here. And then learn from other GDPR compliance businesses in your niche. Reach out to them, just check how they're doing securing of their data under GDPR. And then again, best practices, it's almost the same as you can read it out, that you can see under GDPR and CPRA. By and large, the process remains the same. They don't have the DPIA process, but again, you need to have some sort of a risk management process in place for identifying what are the threats, what is the sensitive processes, what are critical processes, and what you need to do to protect your clients' personal data. And then the practical step towards aligning, discover the data. Number one, heard this saying a long time back, decades back when I started my career. You can write this down if you wish. Never put a $500 fence around a $5 horse. You understand what that means? That the controls that you're implementing should be commensurate with the asset that you're trying to protect. It can even be the other way around. Do not put a $5 fence around a $500 horse. It doesn't make sense, right? You have to understand what is the value of the data, what are the risks, what could be the impact. So first, how many horses you have, what breed of it. So that's where the discover data comes into place, right? And then map the data flows from where it is going, how the data is being adhered to, mapped to, then of course automate the data processing as much as possible. This is something that I might want to tell you, is that I would like to tell you is that, especially under GDPR, there are specific requirements for applications. Ensure that your applications are also GDPR compliant, not just your processes. There are quite a few requirements from application security, not a VAPT or web AppSec. No, how the application is processing data, how the application in itself is working, the privacy policy, the cookie policies, and so many other things which is required to be a part of your GDPR compliant application. So don't just focus on the policies and procedures, also look at the working of your application. And in case you want to know what are those controls, you can again head up to a blog post. There are articles for that too. And again, identify and mitigate the risk, and then finally appoint a company like ours who can do your audit and release the reports for you as a part of due diligence. Now, the future of data privacy, it is evolving very rapidly. Many companies are coming up with it, with many countries are coming up with privacy laws. India is coming up with one very soon. Saudi has a brilliant law in place. Singapore has been having it since ages. Same thing for Malaysia. Of course, the entire Europe is covered. Even Australia has it. Then again, in Canada, there is PIPEDA. US, again, I really hope they don't come up with privacy laws as per state. That'll be ridiculous, hell to pay. I really hope better sense prevails. And then there is a shift in consumer perception and expectations. Slowly but surely, people are understanding the difference between privacy and confidentiality. Many people, including CISOs and CIOs, think privacy is the same as confidentiality. It is not. It is absolutely not. Importance of a privacy forward mindset. When you're designing for an application, our privacy mindset has to be there. Not just a secure application, but a privacy sensitive application should be designed from ground up. Now, building an effective data privacy program with GDPR and CPRA is something that you should look at. Then the evolving privacy landscape, there's an increased awareness and understanding. Use of privacy enhancing technologies, which is there. You can do a search on this. New technologies coming up on how to identify and protect your privacy-based, data. And then again, the technological developments are happening at a very rapid pace. Really surprising, because many companies, I feel a bit odd saying this, but many companies again confuse security with privacy. Like we closed a contract just a few days back. They started off by saying that they wanted a security assessment of their processes and applications. While we were discussing the requirement, we came to know that they were looking for a privacy-based risk assessment, and they were saying it's the same thing. No, it is not the same thing. A privacy risk assessment is different from a security risk assessment. The objectives are different, the controls are different, the deliverables are different, and the expectations are different. As I said, greater accountability to take responsibility, then greater emphasis on data privacy across all industries, not just banks. Earlier, it was just banks, shifted to telecom, but now even FMCG and online portals, gaming organizations, all looking forward to GDPR, to privacy as a base concept. The privacy forward mindset, privacy integration in world culture and process. So in your UI UX design, incorporating privacy based functions, very important benefits. So it helps build your consumer trust. It helps avoid very costly incidents. Just think about it: 20 million pounds, dollars, or euros as a penalty for GDPR, or 4% of your global turnover. Then staying ahead of the business curve and ensuring compliance and meeting consumer expectations. And then again, building an effective data privacy program, understand the scope, appoint a DPO. We have seen this. Identify the types of data. See, look at the immediate steps involved in a discovery of data process. Establish a data inventory. What you are going to protect. Very, very important. What you want to protect. Why you want to protect this. That will lead you to identifying how you can protect it, right? Who, what, when, where, why, and how. The 6 questions. Then again, conduct a privacy impact assessment, not just a security risk assessment. These are two separate things. These are two separate things. A security impact assessment and a privacy impact assessment is totally different. And then again, establish your security privacy policies and procedures. Now, coming up to my final thoughts, they have bought both of these standards the GDPR and the CCPA have brought the much needed attention to the importance of data privacy, right? So for these reasons, businesses need to emphasize and ensure that their application and processes from bottom up, from planning up, should incorporate privacy principles, not just security. Of course, security is required, and privacy does need security principles in place. But again, you can't just focus on one without the other. Thank you again for sharing your valuable time, and I am right on cue for this. Thank you very much for sharing your valuable time. As we exit, do um, fill up the the survey as you get when you exit this webinar. Share your valuable feedback, positive or negative. Give some feedback on how you want us to do our next webinar, subjects that you want us to incorporate. Our YouTube channel, our Facebook page, our LinkedIn page, do ensure that you go through it, connect to it, follow our pages. There's a lot of content that is churned out by our teams for you, just for you. So ensure you're on top of it with our online resources. These are our contact details. Do drop us a line if you think we can work, and drop us a line and we'll get back to you on this. I really hope that this webinar was of good use to you, and I look forward to being in touch with you and seeing you in my next webinar next month. Stay tuned, be healthy, keep smiling. God bless. Bye-bye.